Hi, it's Wendy Hernandez with Command the Courtroom. In today's video, we're going to talk restraining orders because these are things that have been coming up a lot for me in my practice lately. So, restraining orders may be called different things depending on the jurisdiction in which you live. So, for example, in Arizona, there are two types of restraining orders in the family law arena. One type of restraining order is called an order of protection. And an order of protection could be placed into effect by a judge if a person comes in and is able to convince the judge that either domestic violence has occurred in the relationship or that it could occur in the relationship. And in this type of order, you have to show the court that there's some sort of domestic relationship. It doesn't necessarily have to be a marriage, but it could be a boyfriend-girlfriend type of situation or a living together situation, but there has to be some sort of relationship, their romantic relationship. The other type of restraining order that comes into play in Arizona in family court cases is called an injunction against harassment. So as far as injunctions against harassment, there may not necessarily be domestic violence that is necessary to get an injunction against harassment, and there doesn't necessarily need to be a relationship. But a person can get an injunction against harassment, say, for example, if somebody is just calling them over and over and over, or texting them over and over and over, or calling their work over and over and over and won't leave somebody alone. So those are the two different types of restraining orders that I deal with the most. So wherever you are, do your research. If you're in the family law court, find out what the restraining orders are specifically called. Find out what's required to get, if there's more than one type of restraining order, find out what's required to get whatever type it is that you're seeking. Because this is the important point that I want to make today. Over the past few weeks, I've gone to court on a couple of restraining orders, and in both of these cases, I've represented the mothers in the relationship. And both of these mothers are going through divorce cases. In one of the hearings for a restraining order that I have, it was a long, hotly contested hearing that lasted over two different court days. Not the full day, but just, a portion of each day. And I really had myself convinced that we had enough to show the judge that either domestic violence had occurred or that an act of domestic violence or abuse could occur. But the judge disagreed. And the judge decided that he was going to quash my client's restraining order. And it was upsetting to her. It was upsetting to me. But looking back at what she had originally told the court as her reason for wanting that order of protection and what she had written down in her petition for the order of protection, I just don't think that she had been specific enough in terms of what she said that the other party had done. So in the other case, which I just had a couple of days ago, we actually prevailed, my client and I, after a hearing, and the judge was convinced that domestic violence had occurred and that could occur in the future. In fact, in that particular case, the judge took me and the other attorney back to his chambers and, kind of said that he was pretty concerned about my client's soon-to-be ex and that he thought he had some real serious problems. The difference between these two cases was the specificity that each of my clients went into when they initially got the restraining order. The specificity that they put into their petitions. So, if you are seeking a restraining order, it's important really to get your facts together and to be very specific when you're talking to the judge about why you need a restraining order, or when you're writing down why you need a restraining order. And I would get into, of course, specific dates, and just really a lot of details about what happened and when, and how you felt as the acts of harassment were taking place, or the threats of domestic violence, or the actual acts of domestic violence. And if there are acts where you have support in some way, recordings, text messages, emails, obviously those are going to be helpful if the other person challenges your restraining order and you have to go to court and have a hearing on whether it should be upheld. Now, if you are the person who has a restraining order that's been placed against you and you are objecting to that, you think that it was wrongly placed against you, then these are the ways that you can attack the restraining order that the other person obtained. Look at it and see how specific the details are. Are the statements that have been made in the petition very general? Is there any evidence to back up the statements that have been made? And, what's your side of the story? What's your side of things? So in the case that we lost, the other attorney did a really great job of attacking the fact that the details my client provided to the court and in the petition, they just weren't specific enough. So a couple weeks later, when I went back to court for this other case, I was very careful to let my client know that she needed to be really specific when talking to the court about what had happened and about what she had put in the petition for order of protection. So restraining orders are difficult. They're tricky. Whatever you do, don't use restraining orders as a tool in your case. Judges don't like that. Don't use them to upset the other party. Only get a restraining order if you feel legitimately harassed, or if you have been abused in the past, or if there's a threat of abuse. That's what restraining orders are for. Hopefully this helps. So again, subscribe to the Command the Courtroom YouTube channel, like us on Facebook, go to commandthecourtroom.com, download that checklist, and check out all the other goodies. Until next week, keep on trucking, and remember to command the courtroom.